I don't even know if deserve is the right word, but are getting was because of the agreement that your attorney reached with the district attorney for that cap of 15 years. What you two did to Ms. Ordaz is absolutely something, it's out of a movie, scary for a person who is just living their life, trying to run a business. Are there any additions or corrections?
Not from things.
Not from state, Your Honor.
Well, Judge, there is one issue that was brought to my attention this morning by Mr. Alonzo in regards to his criminal history. I think there is a notation there from the federal issue, and according to the report we have that he pled guilty and was sentenced time served. According to Mr. Alonzo, he was granted asylum during that time, and wasn't actually sentenced in that matter.
Is there currently an ICE hold? Can you check, please? Is there, but Mr. Lazo is not here legally, correct?
No.
Okay.
Yes.
Okay. All right, Mr. Lewis, you may proceed with argument.
Well, Judge, Mr. Alonzo, he's been pretty straightforward from the beginning of this case of his involvement. He's taken full responsibility, trying to be as cooperative as possible in this matter so the proper parties and everyone can be made whole, especially dealing with the victim and what they lost out on, even to the point where he didn't know the victim would be here, but he did prepare a letter of apology that at some point he would hope to be able to read or let them know of. He does understand he does have other holes from different counties that has to be addressed as well. So at this time, he's really just asking the court for as much leniency or mercy as possible as far as going forward to resolve this matter.
Thank you, Mr. Nichols.
Your Honor, I took into account his cooperation and willingness to accept responsibility when I capped it at 15. This is a pretty horrific robbery where they targeted this woman who's sitting right over here. He knocked her to the ground while holding a gun. They stole $80,000 in cash from her business. They've been targeting this woman. They've been following her and planning this for months, Judge. And I know another individual was involved. That case is pending. Mr. Lazo did essentially debrief as to how they got there and what they were doing. And that was taken into consideration when the cap offer was made. But the facts of this case, Judge, I think 15 is more than appropriate. She was terrorized. She was brutalized. She was injured. And had to go through this. She lost items that can't be replaced. Some belonging to her late husband they stole from her. They stole her passport along with this huge amount of cash that was from her business. It was obvious they had targeted and sought her out and followed her, and that this was not just some random occurrence, that it wasn't just a crime of opportunity. They came in from Houston to do this, and they've been planning it for some time, Judge. So I ask the court to assess the full 15.
Anything else? Mr. Lazo, I appreciate your attorney's arguments, asking me for leniency, but any leniency that you, I don't even know if deserve is the right word, but are getting was because of the agreement that your attorney reached with the district attorney for that cap of 15 years. What you two did to Ms. Ordaz is absolutely something, it's out of a movie, scary for a person who is just living their life, trying to run a business. And in my opinion, 15 is really probably not enough, but I understand, and I think she probably feels the same way. I appreciate, and I'm sure everybody, including her, appreciates you taking responsibility so that there wasn't a drawn-out trial, so that everybody involved is going to also have their day in court. And so based on all of that, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery, sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement I followed, and so you have given up any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and you need to read it carefully. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. And if you guys will have a seat at council table, we will go off the record for a victim impact statement. Let me ask her. And Mr. Nichols, is she going to do that in English or Spanish?
She has a family member to help to translate, Your Honor. It's going to be in Spanish.
Okay. Good morning, you're Charles Newman. And this is 25 DCCR 0545. Mr. Newman was previously in court, entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. Has everyone an opportunity to review the pre-sentence report?
Yes, we have, Your Honor.
Are there any additions or corrections?
Not with this.
The only addition, Judge, is after speaking with the declining witness, we would request $1,653.75 in restitution.
We are not opposed to that.
1,653?
And 75 cents.
75. Mr. Newman, if I test you this morning, you gonna have anything in your system? Let's double check that first. Have a seat in the jury box. Okay. Anyway, we're back on the record. Excuse me, cause number 25 DCCR 0545, and Mr. Newman's here for sentencing. Ms. tested positive for THC, which obviously gives me some concern.
Which, just to briefly address that, he took a drug test just the other Thursday. That was for work?
No, that was just to make sure like I was doing good and everything. I passed. That's why.
Just to make sure you had everything out of your system
Right,
before you came to court?
Right. I just wanted to make sure that I was doing like.
He had surgery a month ago.
And then I had.
Stop talking over your attorney. Let him talk.
He had surgery a month ago. He took narcotics as part of that. He's a prescription for that. But he took a drug test just to see if anything was going to show up. Nothing showed up.
Well, THC isn't have anything to do with
That is
a
correct.
surgery.
That is correct.
He's admitted that he uses marijuana. That's
Right.
why I had him tested today. So at some point, you used marijuana, and you clearly were making sure it wasn't. If you had a prescription for narcotics, that's not what you were worried about. You were worried about testing negative or positive for marijuana because you admitted to the probation department that you use. And so stop. Take responsibility.
Yes, ma'am.
You shot at a car going down the interstate because they cut you off.
Yes, ma'am.
You barely missed a person in a car because you got pissed that they cut you off. And you're going to sit here and argue to me about using marijuana? I mean, this is crazy. What you did is crazy. The deal you're getting is amazing. And I would think you would come in here absolutely clean, not hoping you're clean and testing positive the week before because you might have used something that might not be out of your system, which is where we are today. All right, anything else before I sentence Mr. Newman?
Judge, I just point out a couple of things that are in the PSI. This is a severe situation, but it's certainly out of character. Mr. Newman has never really been in trouble of any kind before. So this is definitely certainly a one-off. He's always remained employed, had good employment. He did lose his job as part of this case, but he's had surgeries recently and he has work lined up. So he is intending on, continuing to maintain the normal life that he's always held, other than this particular incident. Obviously, if marijuana use is a concern, if he can't stop using marijuana, they're going to figure it out at probation, whether that's drug testing or a patch or whatever the court decides is necessary for that. But it's not using, worse drugs that would be even more concerning considering this case. So we're just asking the court to follow the deal and impose whatever drug conditions the court deems are necessary.
Mr. Smith, anything else?
No, Judge.
All right, so Mr. Newman, what I'm going to do, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 10 years. You're ordered to pay a $1,000 fine. You're ordered to pay restitution in the amount of $1,653.75. You will be ordered to enter and successfully complete the JCDI program, which is an intensive outpatient treatment program. Obviously, if you're using this close to court, you're going to get some treatment to make sure you're not. You will be required to wear a drug patch until further order of the court. I am also going to order that you serve 15 days up front in the Jefferson County Jail. And so you'll talk to probation today. You will go into custody. And this is just too serious of a case for me not to make sure you understand some consequences of your actions. To be coming in here for shooting at someone in a car, testing positive, is just, it's not okay. And you need to understand that. So this is still an amazing opportunity. You don't have a felony conviction on your record. So if you successfully complete the probation, and Mr. Galmore's right, this is apparently seems to be very out of character, but it's so serious that it's just something's going on and we're going to get that figured out. And so if you do everything you're supposed to and you're successful on this probation, the case gets dismissed at the end. You will never be a convicted felon. But the other side of that is if you violate any condition of probation, you will be brought back into court. You could be found guilty of the offense, and you could go to prison for up to 20 years, anywhere between 2 and 20 years for this offense. One of the things that makes me a little more comfortable, I guess, you're very lucky that the victim of this offense, number one, didn't get hurt, and number two, is in agreement with you getting this help and being on probation and making sure you follow through. So you should be very appreciative of that. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You can go with the bailiff. Probation will talk to you in just a few minutes before they take you back.